Hi. I just wanted to know if you signed up for one of the committees.
I'm sorry.
If you signed up for one of the committees.
Yep.
In the sign-up sheet that we used last meeting, are you still being considered for those committees?
Yes.
Even though you didn't fill out the paperwork?
Yep. If you signed up at the meeting, even though you didn't fill out a form, you're still being considered because you expressed it. I would like, though, if I do choose you, I would like to have that information because that's what's helping me to determine how diverse of a group I have. So that information is helpful in that regard. But it's not exclusive to your ability to possibly serve.
Okay. I'm still not really clear on why the union is not supporting many of us. Because as you just said, some of the problems arose 2014. I was working at FATM in 2014. So as an employee, if I had a problem with a patient, they would have supported me. Why do they throw me out now?
Well, I can't speak for the union. They're not here tonight. But I will tell you that in my discussions with members of the union and their attorney and Jack Callasy, they don't view this as a union, non-union issue, as a retiree, non-retiree issue. This is an issue that's affecting all of you. They have a position that they're going to advocate for, which may be very similar to those who aren't currently in the union or never were, for that matter. So I think there's it's difficult to say that they're not there. They have a group that they represent. It's their current dues-paying members. That doesn't mean the position that they're going to be advocating for is adverse to those who aren't dues-paying members. It's just that that's just the identification of the people who are currently paying dues and who they currently represent. I would encourage you to reach out to them because I think that you will find when you speak to them that they are of the mindset that this is we may have different ways of getting to the destination, but we all want to get to the same place.
Okay.
And they probably work with you to the extent that your thought process was in line with their thought process.
Okay, thank you.
Sure.
Hi.
Hi.
I just, it's not going to be a popular statement, but what also hurt the pension was that when it became Prospect, people that were employed and are still employed there are collecting their pension. When I retired, I had restrictions that I couldn't work so many days per year, or I would lose my pension. If I went over that number, I would lose my pension for the rest of that year because I went back per diem. But now, there's no restrictions, and from what I understand, I could be wrong, a lot of people employed took early, started collecting their pension while they're still employed full-time. And that put a big burden on that pension.
I will say that I am aware that as a result of that transaction, one of the, I guess I'll call it the unique aspects of a transaction like this, what happens is that Old St. Joe's technically has to fire everybody.
Yeah.
And then a minute later, New St. Joe's Prospect has to hire them. And under the plan, a termination of employment triggers your ability to start receiving benefits under the plan.
Yeah.
So that issue, that 1 second issue, created the ability for people who are still working to take advantage, if they were 55 years of age or older, to start taking advantage of that pension. I'm aware of that. I will say, although I don't have any hard, solid numbers, I would not. That might have helped the plan, assuming nothing else happened. It may have taken a run-out period of, say, 12 years and extended it by a year, 6 months, a year, maybe a year and a half, but it did not have any, what I'll call, like, devastating impact on the speed of the drain of the funds from this plan. The problem is that there's no money going in, and not even enough money up through June 2014 went in. like I said, even if they had put $28 million in 2014 and made it 125% funded, we'd still be here today. We wouldn't be looking at 10, 12 years for a run out if nothing's done, but we'd still be here today talking about what's going to happen.
Okay. Thank you. You answered my question.
Thank you.
Hello.
Hi.
I have a question regarding ERISA.
Okay.
And it being a diocesan pension plan, as the court has indicated right now, to a certain time. And what is the potential or the possibility of it becoming subject to ERISA and us having any type of recovery in the future from the federal government that we're paying our taxes into?
Okay, so you're talking about the only way that the plan can have recovery from the federal government is through the Pension Benefit Guaranty Corporation, which is the federal insurer for plans that fall under ERISA. This plan, and you said that the court...
There was some indication by the court that they're calling it a church plan.
Correct. Okay, that's an accurate statement. St. Joe's has designated this plan as a so-called church plan. Church plans, which are plans that have an affiliation with a religious organization and follow the teachings or the theories, philosophy of that religious organization, are exempt under ERISA, meaning they do not have to report certain things, they don't have to fund on a regular basis, and they don't have to pay insurance to the PBGC. The PBGC is an insurance entity for pension plans. One thing that I am looking at is whether or not that designation was appropriate. Even if it was appropriate for some time, did it end and they continued using it for a period of time? One thing that hasn't been addressed, it's been a hot issue right now, but what exactly is a church plan and what exactly is the PBGC's responsibility if a plan designated itself as a church plan, but that was an inappropriate designation? I guess all I can say to you right now, I can't speak too much on it because I am looking into this,
okay,
but I do have to be careful because under the only thing that we know is what the PBGC does when a plan like this is underfunded, orphaned, or terminated. That has been paying benefits to the PBGC. This is a circumstance. Excuse me. Think about your car. You've got a car, you don't have car insurance. And you get into, God forbid, you get into an accident. And you call up an insurance company and say, you actually would have been my insurer had I paid you premiums. Just so you know, I got in an accident a couple of hours ago and I need you to pay out that. That's what we're basically asking the PBGC. We've never paid a payment to you, or we'd be looking to the PBGC. We've never paid a payment. There's a problem here, and now you need to come in as if we paid payments all the way along. Those payments, by the way, based on the current assets, would be somewhere about $1.2 million a year. So, as you can imagine, the PBGC is generally not anxious to provide coverage, just like all insurance companies are never anxious to provide coverage. They're even less anxious when you don't pay them premiums. And this issue is absolutely novel around the country. Not that you want to be part of this distinction, but a plan like this has never been in a situation like this, and the PBGC has never been faced with a circumstance where a plan has considered itself a church plan. There's a potential that that might have been an improper designation, that they've never paid a premium, and then to add to that, they go into an insolvency proceeding. They're controlled by the court. So we're in new territory. I've spoken to people in other states around this country, and they're kind of scratching their heads saying, how are you doing this over in Rhode Island, and can you let me know how this works out, because we may want to do it. But it's one of those things I'm looking at. The one thing in all seriousness that I have to be careful about is because I don't know what the PBGC would do if I were successful in being able to get them to come in and cover. It's one of those where you need to be careful what you ask for because you just might get it. I know what I can potentially do for this plan to keep it alive going forward. And I know what that potential result is. Obviously, there are a lot of factors and time changes and market changes and things like that, but I don't know what the PBGC would do because nobody's ever addressed the situation. And what I'd hate to find out is that I push to have the PBGC come in, and as a result of the PBGC coming in, some of you get nothing, everybody only gets like 20 or 30% or something like that. So I have to be very, very careful at how I tread, because I'm proceeding down a path that's nobody's ever walked down, and there's no rules for what the PBGC would do. So until I have a better handle on what they would do, I don't want to push the issue too much. I've spoken to them on a few occasions, and I can tell you the tone of the conversations are, this was a church plan, thank you, we're not dealing with you.
So if you settled with the diocese and they miraculously came up with some money and said, we're washing our hands now, it's obviously no longer a church plan, and the plan still has to be managed, is there a possibility of entering under that auspices at that time?
There's a potential. The potential for the PBGC, I guess, argument case is out there. And I'm looking at all avenues, and I'm looking at the ones that are going to be, for lack of a better way to put it, the low-hanging fruit, the ones I can deal with most easily that gets money into the plan, and the ones that I have some predictability with. I'm looking at everything all at the same time, but as I move, maybe the PBGC issue will clarify itself for me before we're able to pursue somebody else. But it will be out there. And quite frankly, that's part of the issue now, is now that this plan is in a receivership proceeding, is it even a plan anymore? That's a question that has come up, or is it something else that the court proceeding has created, like a liquidating trust or something like that?
Okay, thank you.
You're welcome. Any other questions? So you guys, this is a quiet group tonight. Either you're tired of me, or you're just plain tired, or... No. Okay. If there are no...
Could you just estimate a ballpark idea on how long these proceedings will go about? And can we identify some kind of a year end?
I'm going to have to answer that in two ways. The litigation piece, so the investigation of potential claims, let's assume for the moment we identify claims and the pursuit of those claims, assuming no settlement is reached. Likely litigation like that would go about 2 to 3 years. Okay? You saw it with 38 Studios. I think the litigation in 38 Studios, although there were many, many more players involved there, I think that took about 4 years to conclude. So I'd say anywhere from 1.5 to 2 years to 3 to 3.5 years on the litigation. For my role, if what I hope can be achieved, meaning get the most money into this plan and be able to manage this plan, these assets, so that everybody who's vested receives a payout through their last day, then although I won't live that long, hopefully this proceeding would live that long. So we're talking somewhere between, I think the youngest, about 32 years old that we'd seen, 31, 32. So somebody in low 30s able to retire at about 55 and then live through actuarial tables till about 80, 81 years old. So you're looking at about 45 years, give or take, for the last person. Ideally, that's how this plan should proceed. So I hope we're able to do that, and I hope you'll like me, because I'll be around at least until I retire. Because the alternative is that something, if I'm not in place, either we've successfully argued that a group like the PBGC should come in and take over, and that would result in a better result for everybody. And then I'd be out. And the plan would be dealt with by the PBGC under whatever scenario is that. The other scenario, which I think is not as good of a scenario as what I can provide, is to terminate the plan. And to terminate the plan means take the money that's there now, look at the people who are currently receiving, pay them a percentage in an annuity, and then everybody else gets nothing. So I view that as the worst case scenario, and something that this proceeding was elected to avoid. And then there is potential out there that something like the PBGC, or maybe we can get somebody to say, you know something, the right thing to do would be to take over that plan and fund it and keep it going, and then I wouldn't be around. But absent either one of those scenarios, you'd got me for the next 45 years or so.
I just want to say that I was very impressed with what you've done so far, and I think that we have a good person in place. Thank you very much.
Just a quick question. I applied for benefits a couple of months ago, and I know there's a bunch of us that did. How long do you think it would be before those applications are processed?
I can't speak for the court, but if the judge asks me, once I'm in a position to make a benefits adjustment, I'd be asking the court to lift that postponement. Just so you know, part of the reason I did that was because I need the water, as I've stated, I need the waters to stay calm. Mm-hmm. That said, I still need to understand if all of those applications were triggered, how much more that would impact the monthly benefits. So I have that information. I've asked for it, I've gotten it. So that comes into play when I am thinking about what needs to be done in February, is not only assuming that the judge will flip the switch and allow those to be done, but I also have to look at the worst case scenario that every single person, whether they've applied yet or not, that it will be eligible, will apply as soon as that switch is flipped.
Right.
So I've got my worst case scenario in terms of monthly benefits that will affect how I address a benefits cut in February, but hopefully in February.
Well, no. Thank you.
Sure.
I have just one question.
Okay.
In addition to the AG in the diocese, can Prospect be held liable at all for any of this, knowing that they knew the pension was underfunded?
So the question is, in addition to the AG and the diocese, can Prospect be held accountable? I'm looking at everybody. Like I said, you've seen the motions to compel the AG and the diocese merely because those subpoenas went out and they haven't responded. Prospect was represented by counsel at the hearing on the motion to compel the Attorney General, and indicated that they'll be working with us and they'll provide documents. Quite frankly, they are almost, in asking for much of the information from Prospect, it's really coming through St. Joe's, the old St. Joe's, because they were so tied together with the transaction. So I did subpoena the old St. Joe's for books, records, and documents, and they are working with Prospect because two reasons. One, some of the documents that I've asked for under the transaction, Prospect now owns, they bought, and those that they didn't buy, they are still they're the keeper of those records right now. So I'm in discussions and negotiations with Prospect right now to look at all of those documents, but everybody is in play. If somebody had something to do with this plan, I am looking to see what their role was, what they did, what they didn't do, what they should have done, all of those things. And at the end, we will have, hopefully, a list of people that we can tell you we believe were responsible in some way, shape, or form for what happened, and we're going to try to hold them accountable. And hopefully we're successful.
Thank you.
That was somewhat along the line of the question I was going to ask, which is, does Mr. Wistow or you, do you have a rough estimate how many either people or entities right now that you plan on trying to get them to talk?
Investigate?
To talk, yes.
Yeah.
Investigate.
So, I mean, there are the obvious players. So there's the Rhode Island Attorney General, there's Prospect, there's St. Joe's, there's Mercer, who is the investment manager, there's Angel, who is the actuary, there are the boards. But quite frankly, as we receive documents, new names and entities come up that we didn't know about. This plan's been around for a while. And there was a transaction in 2009, and there was another one in 2014, and there were activities before those two transactions. So while those are the obvious ones, the ones that probably each one of you know that exist out there, as we receive these documents, we're identifying new people that we have, okay, what did they have to do with this? What did they know? What didn't they know? What role did they play? That's why it's so critical that we get the documents, because not only will it tell us what the group did that we're asking the documents from, but it may also give us new paths to pursue to see if there's somebody else out there that we didn't previously know about.
I have to say, this sounds like a game of whack-a-mole.
Litigation can be like that. In a case like this, it is like that. You've got a number of parties, and you start going down different paths, and sometimes you realize you're at a dead end, and it wasn't worth pursuing, and then sometimes it travels down someplace that you're happy to go.
Okay, thank you.
Thank you.
You mentioned the entities there. In 2009, it was my understanding that September 30th, 2009 was the end of the St. Joseph, the old St. Joseph's Health plan. And then they went to a 403B plan starting October 1st of 2009. That was in preparation for the merger or consolidation of Roger Williams and St. Joe's. It's my assumption that Roger Williams has never had any problems with their retirement plan. Are they a member of this ERISA or PEGC? They're not a church plan.
The only I don't claim to be an expert on ERISA, although I will tell you I know more about ERISA today than I ever wanted to know. But I can tell you that I'm not aware of any other exemption like a church plan status that exists in ERISA. So Roger Williams, I'm going to assume, although this is just an assumption, I'm not basing this on anything, that as a hospital that had no affiliation with any religious organization, that it was a qualified ERISA plan and was required, to the extent it had a pension plan, they were required to treat that plan in accordance with ERISA requirements.
Okay. When they merged St. Joe's and Roger Williams and it became a legal entity, Charter Care, and from 2009 through 2014, the sale to Prospect, it was my understanding that they didn't sell St. Joseph's and Roger Williams. They sold Charter Care to Prospect as one entity, Charter Care, being sold to Prospect. That sale was approved by the Attorney General. And he didn't separate or break out Roger Williams and their retirement plan and St. Joseph's and their retirement plan, be it the old plan or the 403B. It was just Charter Care being sold to Prospect. And, that's what's confusing me, is how are they getting separated? And Roger Williams presumably is covered by ERISA, and they were part of the entity called Charter Care, which was sold to Prospect. But now they're being separated and saying, well, St. Joe's isn't covered, Roger Williams is covered. You know,
The questions that you have in your head are what I'm trying to answer. That's what I was talking about, is whether or not the church plan status, while it may have been, let's assume for the moment it was appropriate through a certain period of time.
Right.
That doesn't mean
2009.
plans can, or entities can change, and the church plan status may or may not have been appropriate at different times during this plan's life. It may have ceased, bless you, it may have ceased to exist as a church plan at some point in time and just continue to consider itself a church plan. Because keep in mind, it's a designation that the entity makes. They're supposed to get letters from the IRS and things like that, but essentially nobody calls up to question them until something like this happens, or until the plan members go forward and challenge that designation. So I'm trying to figure out whether or not there was a point in time where maybe it wasn't appropriate, and therefore that's how I can argue that PBGC could potentially come in if I think that's prudent.
Okay, thank you.
Sure. I could tell you, ironically enough, in July, there was a hospital, St. Joe's Hospital in New Jersey, and not an insolvent hospital. It wasn't a sale, but they designated their plan as a church plan, and the members challenged it. I will tell you that that resulted in a settlement, so it never actually went to court, so we don't have anything to go on in terms of precedent, but the hospital backed off and actually changed their designation from a church plan to an ERISA plan and started obligating themselves to make payments under ERISA. So that exact question is something that's here, is people can challenge it. Just because somebody says that it should be a church plan doesn't necessarily mean it is or was. And I'm trying to look at what those circumstances were here, and if they ever were appropriate, and if they were appropriate, did that appropriateness end at a certain period of time? Okay. If there are no other questions, I appreciate everybody for coming out. We do have a hearing tomorrow. Once I have the information regarding that hearing, it'll be posted, order, and whatnot. I'm sure you'll hear about it in the news as well. And obviously, email address and everything is still up, and we'll try to answer all the questions that you guys come with. Thanks for coming out, everybody. Have a good night. Thank you. And if I don't see you before, have a happy holiday and a safe holiday.